Hello, hello, hello. We have Chief Firewater appearance that's supposed to be happening, and in the meantime, I'm gonna go ahead and stream this appearance in 3B. It was first sent to me by Marion, but then everybody else sent it to me. I haven't seen it, but it's probably delicious. Let's do this thing, shall we?
The victims in this case, they're his adoptive parents.
Yeah.
Were they his adoptive parents, correct? Or are they biological?
I didn't know the difference.
I don't know, but they're his parents. I know it because he kept saying, these aren't my parents, this isn't my parents.
All right, we're going live here.
Oh yeah, we're going live.
Thanks for coming, Josh.
So this could potentially end up on Law Talk, so everyone behave. That's what he really meant. I'm having some serious Wi-Fi issues at my current location, so tell me if it's not working.
Good morning, sir. Can you hear me?
Yeah,
Are you James Juday?
yeah,
Would you rather stand or would you like to sit down?
I'm good.
All right, I'll leave you standing if
That's
you're all right with
debatable.
that. This is file number 24803FY. It's entitled People of the State of Michigan versus James Charles Juday. Mr. Juday is presently connected by a Zoom link from the jail. His lawyer, Rhonda Ives, is here with me at the courthouse, and Chief Assistant Prosecuting Attorney Joshua Robert is here. Mr. Juday, to recap, you got charged on May 15th with home invasion in the 3rd degree for a dwelling on Hiawatha Drive in Sherman Township. That's a felony punishable by up to 5 years imprisonment and a fine of up to $2,000. You also got charged with malicious destruction of personal property. You broke a window allegedly and spray painted some things on the house. That's a misdemeanor alleged to be over 200 but less than $1,000.
None of
Punishable by-
So why am I here?
All right, here's why you're here. The matter was set for a preliminary examination and a pre-exam conference. Your attorney,
Yeah.
Rhonda Ives, was appointed to represent you, and you basically wouldn't talk to her.
There's nothing to say. I didn't do nothing.
All right, well, so we've referred the matter for a competency evaluation at the Center for Forensic Psychiatry. And we got a report from the Forensic Center on August 13th. It was date stamped
I
August
sure am.
16th. We're supposed to set a hearing in that matter within 5 days of the receipt of that report. Today's 4 days after we received it. So this is a hearing regarding your competency to proceed. You've been stuck in jail now for 97 days and the case has just been on hold.
It'd be nice to get a real lawyer too.
All right, well, we'll talk about that. Mr. Robert, on behalf of the state, are you willing to stipulate to the admissibility of the report?
Yes, Your Honor.
It is dated August 13th from Carissa Carlson, PhD, a consulting forensic examiner and licensed psychologist with the Center for Forensic Psychiatry. Ms. Ives, are you willing to stipulate to that report?
I would stipulate to it, but I object to the conclusion that's been made in the report based on the lack of review of and interview of the defendant.
All right.
You want me to plead guilty to something I didn't do? There's nothing to talk about.
Well, I don't necessarily want you to plead guilty. You're entitled to have a trial. And your lawyer is willing to represent you at a trial, but in order to do that, you have to talk to her. No one's trying to get you to plead guilty to anything. We're trying to just move forward with the case. And
Didn't do. I did
All
talk
right.
to her.
All right, well, here's what the psychologist says. First of all, competency has to do with your state of mind right now, today, and the day of the trial. Criminal responsibility, sometimes referred to as insanity, has to do with your state of mind at the time of the offense. We're not concerned about that right now. We're just concerned about your state of mind now. I get the sense that you're an intelligent guy, but you've got some oppositional issues. The statute, the competency statute says, a defendant to a criminal charge shall be presumed to be competent to stand trial. He shall be determined incompetent to stand trial only if he is incapable because of his mental condition of understanding the nature and object of the proceedings against him or assisting in his defense in a rational manner. The court shall determine the capacity of the defendant to assist in his defense by his ability to perform the task reasonably necessary for him to perform in the preparation of his defense. So the examiner didn't get very far with you. The video conference lasted about 5 minutes. Mr. Jude terminated the interview prior to being asked questions about his legal case and understanding of the proceedings. He demonstrated the ability to advocate for himself as evidenced by his understanding he could terminate the interview. So here's the doctor's opinion, Mr. Jude. I was unable to thoroughly assess Mr. Jude's mental condition at the time of the present examination due to his declining to participate in the evaluation. Because of this, I was unable to directly ask him questions to assess his understanding of the nature and object of the proceedings against him, or to assess his ability to rationally assist in his defense. So they didn't get very far. Then she goes on to state, an opinion on competency is required regardless of the level of participation of Mr. Jude. The time of the evaluation is reported refusing all psychiatric medication.
I don't need medication.
All right, okay, that's, in my opinion, due to the limited, well, let me finish this last part, then I'll let you tell me what you want to tell me.
Go ahead and look.
Well, okay.
That's how I'm being treated in here.
All right. In my opinion, due to the limitation of not being able to directly evaluate Mr. Jude myself, and my understanding of the statute, one has to opine the presumption of competency. So their opinion is that you're competent. You're standing there with no shirt on. You're trying to show me how thin you are because of
how I'm being treated in here. Yeah.
All right.
Exactly what I'm doing.
All right. So you showed me that because of how skinny you are?
No, how I'm being treated in here. Boys and gas, all that shit, you know about it.
So that isn't exactly a rousing endorsement for the doctor to find that you're competent. Mr. O'Bear, you have any thing to say about this?
In my review of the statute, the only other possible thing that I can see is for Ms. Ives to request an independent evaluation as one of the outcomes of this hearing. But it says that because of the presumption that the Center of Forensic Psychiatry or other facility officially certified by the Department of Mental Health will properly perform their functions, good cause justifying an independent competency examination should only arise in exceptional cases. So I guess that's one possible option. I don't know if any evaluation by any other person would result in a different outcome based on his unwillingness to participate.
All right, Ms. Ives, What's your position?
Well, Your Honor, I have some serious concerns if they're not able to fully interview the defendant. I don't believe that an accurate determination can be made, and based on statements that he made to me prior to, that caused my request for the competency evaluation causes me some great concern. I'm also concerned the fact that there were reports from the jail that the jail was supposed to send, and they, if I look on page 2, those records were supposed to be sent on August 8th promptly, and then as of the date of the report on August 13th, those records were not received. I'm not sure what is in those records, and I'm not sure, but I think that they would be very appropriate to review, as well as have a full evaluation with the defendant. I mean, if that means we have to do an independent valuation, I guess I would ask the court to allow me to find the resources to do an independent valuation, or refer them back to Miss Dr. Carlson so that she could try to re-interview the defendant, and hopefully he'll just cooperate with that interview so we can make steps and proceed forward.
Well, Mr. Jude, what was scheduled was a preliminary examination and a pre-exam conference. This is a felony charge. One is a felony, one is a misdemeanor. You've got a $20,000 bond, and everything just gets stopped in a timeout when there's a competency hearing.
Got any proof on anything? No.
So we weren't able to do the pre-exam conference, and we weren't able to do the preliminary examination. So I ordered this evaluation, and they did it, but it didn't go very well because you weren't very cooperative. So go ahead, sir. What do you want to tell me?
I've been telling you everything. There's nothing what do you want to know?
Well, do you want to go forward with your case? Do you want to have a trial? Prosecution has to prove the case beyond a reasonable doubt. We can't move forward in the posture we're in right now.
Well, yeah,
You
I'm
don't
not trying
have
to stay in here for no reason, man. I'm already in here for no reason over 90 days. Did you look at
97
me?
days.
You see how skinny I am and shit?
Yes.
Yeah, you know,
Let me ask this. If I were to release you today, where would you go?
I don't know. I'd figure it out.
Well, I'd rather figure it out first.
Well, I gotta be able to get my shit.
Yeah. Well, are you willing to talk with your attorney so she can proceed to prepare your case for trial?
I don't care, man. If it gets me out of here. You see me, I'm starving, man.
Well, I see it. All right.
Getting poison every day. Gas, yeah.
Say that again.
Getting poison and gas every day too. I know you don't care, but
What's that from?
ask them.
Did you say he was poisoned with gas? Mr. Jude,
Yes.
is that what you said?
He said he is poison gassed every day. The jail staff says you're on a quasi hunger strike and that you refuse to eat.
I've been eating.
All right, well, do that.
Your Honor, I'm confused. Is he making a statement that, what does that mean, poisoned gas?
Well, you heard the same thing I did. He contends he's being poisoned by the jail staff with poison gas. And he said, ask them.
You gonna let me out today or what? You just said something about it.
No, I just asked what you would do if you had somewhere to go. No, I'm not inclined to let you out without cooperating with your attorney. I can't even get to the first stage of the proceedings. You've been in jail for 97 days. If I order an independent psychiatric evaluation, it's probably going to take another 90 days. I don't believe that you're being poisoned by poison gas at the jail. It doesn't matter what I believe, if you believe it. So what would happen if I find you to be competent? I would set the matter for a pre-exam conference where your lawyer would come and meet with you and discuss what to do with the case. It could be reduced with some sort of a plea agreement, or you could have a trial. Nothing prohibits you from having a trial where you have to be proven guilty beyond a reasonable doubt. But we can't even get to that point. This business about your belief you're being poisoned is new to
Can you buy
this.
me out? I've already tried. They won't let me.
Well, your
Okay.
bond is $20,000 cash or surety.
Yeah. I've already tried.
Well, there were
the whole-
also allegations that you violated a personal protection order. That's why the bond is so high. You kept going back to a place you were ordered to stay away from.
Well, I gotta go back to where my stuff is.
Well, we'll get to that point. At this point, I'm inclined to grant defendant's motion for an independent psychiatric evaluation.
And you do what you gotta do.
All right, thank you, Mr. Juday.
I'm
We'll
talking to
have-
somebody.
Now, what I'd like you to do is cooperate with the next doctor and see if we can move forward here. 'Cause
I'll talk to the doctor. There's nothing to talk about, but.
all right, I asked
need
you to
to-
cooperate. Maybe we get,
I mean, come on.
all right, well, I've seen enough of that. So, all right, Mr. Juday, have extra French fries or something. I'll be seeing you at our next hearing.
I wish I was eating.
All right,
Let me look at the order,
we're gonna pick it up.
see what it says.
That was crazy.
For a docket call. What's our status here?
Thank you. Speaking with Ms. Goodrich this morning, I think we need the court to select trial dates at this point. We're still talking, but I think at our last status conference, we had discussed that this be asking for at least trial dates to docket the case for.
Okay, let me take action to do that.
All right, does anybody see him? I'm a little bit behind.
She's not in custody. People
No, Your Honor.
from the defense.
Awesome.
And what else do you have with me this afternoon, Mr. William?
I have jury status conference on Gregory Frisky. He is here at my office. I'd indicate to the court that we don't have that case resolved as of yet. If the court could set up for status conference on the same date, that'd be fine. The 17th.
Okay, and that was on who?
Gregory Frisky, that'd be your file number
Okay.
24-6860 FH.
Okay, so on people be frisky, we'll schedule this for a docket call.
I was just told this is happening. I don't know for
17th at
sure.
1:20.
We might just be having a wild goose chase with Judge Gothier. But if you're going to have a wild goose chase, who would you rather have it with? Honestly,
Anything further from the people on that file? Okay. From the defense?
No, sir.
Is it all you had with me today, Mr. Clay?
I just have a Craig Johnson on a completed delay of sentence. He's here at the office. I can grab him quickly.
Okay, yeah, let's do that, get that done.
Craig. Craig, come on back. Talking about Greg, right? Craig, both of you can come back. You sort of take that out. He's-
All right, and this is People v. Johnston, file 23-6685 FH. It looks like it's sentencing after a successful delay in the plea called for reduction to 2 misdemeanor counts of assault. Anything further from the defense, Mr. Clay?
No, sir, I'm just happy for the opportunity. I think Mr. Johnston completed all the requirements that were expected of him. Probably learned quite a bit about this, even in his pre-sentence investigation report back when it was completed. Showed contrition, remorse, and the fact that he lost control in a situation that could have been avoided. I think that all is still true in his life, and I'd ask for just to follow the terms of the plea agreement.
Okay, thank you. Mr. Johnson, it's not required that you would say anything. Do you want to say anything or no?
No, sir, I don't have anything to say now.
Okay, thank you. Any recommendations from people?
I also congratulate Mr. Johnson for taking this opportunity to successfully complete the terms of probation. And if I can approach, I do have the amended.
Okay, very good. All right, well, Mr. Johnson, the court would find consistent with the report from the supervising agent that you have successfully completed the terms of the delay and accepted amended information that includes counts 3 and 4 misdemeanor assault, and will enter a judgment on those 2 misdemeanors with no further sanction. Because a judgment is entering on that, you can file an appeal if you wish by filing an application to the Court of Appeals. We're going to send that appeal paperwork to your counsel, and he can get that to you if you want to file an appeal. Any questions for me, sir?
No, sir.
Okay, good luck to you. Good day, Mr. Clean.
Thanks, sir. You as well. Thank you.
All right, we've got Mr. Martin. Add on here.
Thank you, Your Honor.
Yeah, last we saw Chief Firewater, he was in the clink.
This is file 24-6880FH.
They might have to pull him out.
Early, it was scheduled for an arraignment in September. So for purposes of arraignment, is a forensic center referral requested?
No, Your Honor.
Okay. And you waive the reading of the information?
I do, Your Honor.
All right, and you know what? We don't have the actual court file in the courtroom, and in my working file, it's a new enough file. I don't have a copy of the information. Somebody share that with me here.
I don't have it as well. He is charged with delivery of a 7-year, which is Adderall.
Delivery Adderall, the 7-year, or 25,000 or 50.
Yes. I can give you that code in just 2
Oh, that's
seconds.
fine. Oh, I might have it right here. All right, thank you.
Zoom is great for that, isn't it?
Yes, all right, Mr. Martin, as best you can, would you raise your right hand for me? You swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
Mr. Honor.
Please put your hand down. Are you Michael Charles Martin?
Yes, sir.
The guilty plea hearing is an important event. It includes the waiver of constitutional rights that you have, so listen carefully. If you have a question, ask me. I'm happy to answer it. If you need a minute to talk to your lawyer, just let us know. We're happy to give you that time. I have to advise you the maximum penalty for the charge of delivery of amphetamine, which is the Adderall would be that, is a felony punishable by up to 7 years and or a $10,000 fine. Do you understand the maximum penalty?
Yes, sir.
And was this committed while on bond for the other offense?
Yes.
Okay, so it's discretionary consecutive, and I don't have that file in front of me, so I don't know the maximum penalty that you face there. But you understand that this would be in the court's discretion consecutive to whatever sentence I impose in the other file?
Yes, sir.
All right. And do you understand if you enter a plea, you won't have a trial of any kind, and you'll give up the rights you would have had at trial?
Yes, sir.
I want to remind you of the most important of those rights. You'd have the right to be tried by a jury, and at that trial to be presumed innocent unless and until the prosecutor proves your guilt.
Was he up earlier?
Do you understand that?
Yes, sir.
Seriously?
At that trial, you'd have the right to have the witnesses against you appear, the question.
Tell me where, and
You'd have
we'll
the
go
right to
back and
present
watch it.
witnesses in your own defense and have me order them to show up. And you'd have the right to testify in your own defense or to remain silent and not have your silence used against you in any way. Do you understand that?
Yes, sir.
Do you wish to waive those rights and enter a plea here today?
Yes, sir.
If I accept your plea, you can't come back later and tell me that it wasn't your own free choice to enter it for any reason at all, including promises that may have been made to you or any threats. Do you understand that?
Yes, sir.
Also, when you enter a guilty plea, you waive the right to appeal, and if you wanted to appeal, you'd have to file an application to the Court of Appeals and seek permission to appeal. And the types of issues that you could raise on that appeal are much more limited than if you were convicted after a jury trial. Do you understand that?
Yes.
The plea agreement provides in exchange for your plea of guilty to the count 1 that I outlined, the prosecutor will dismiss all the enhancements, the habitual enhancement and the drug double enhancement. Do you understand the terms of that plea agreement?
Yes, Your Honor.
Ms. France, is that a full, fair, and accurate statement of the terms of the agreement?
It is, Your Honor.
Ms. Goodrich?
Yes.
Mr. Martin, other than that plea agreement, has anybody promised you anything to get you?
No, Your Honor.
Has anybody threatened you to make you?
No, Your Honor.
Is doing so your own free choice?
Yes,
Knowing all this, how do you wish to plead the charge of delivery of amphetamine?
guilty.
So on or about April 18th of this year, 2024, were you within the confines of Sheboygan County?
Yes, Your Honor.
And did you deliver the controlled substance amphetamine to another person?
Yes, Your Honor.
Did you know that you were delivering amphetamine or Adderall?
Yes, Your Honor.
Do you have any lawful authority in the state of Michigan to dispense that substance?
No, I do not. Your Honor.
And that delivery occurred in Sheboygan County?
Yes, sir.
Ms. France, are you satisfied with the factual basis?
Yes, Your Honor, thank you.
Ms. Goodrich?
Yes.
Ms. France, are you aware of any other promises, threats, or inducements?
There are none.
Ms. Goodrich?
No, Your Honor.
Ms. France, in your judgment, has the court fully complied with the requirements of MCR 6.302?
You have.
Ms. Goodrich?
Yes, Your Honor.
Okay, I don't think Chief
Well, Mr.
Firewater's been called
Martin,
yet.
I find that your plea is knowingly, understandingly, and voluntarily made, and that there is a sufficient basis in fact and law to believe that you're guilty of that offense. So I hereby accept your plea. And I see we're up for sentencing in the other case on September 10th at 1:40. Did you want this at the same date and time then?
That would be perfect, Your Honor. Thank you.
Okay, we'll schedule this for sentencing September 10th at 1:40. Someone from the Department of Corrections may be meeting with you so they can prepare a pre-sentence report in this file. Anything further from the defense?
Just one thing, Michael, you understand you have a right to have your defense attorney present for your PSI interview. Do you want me there? Thank you, Your Honor.
Okay, anything further from the people?
No, Your Honor, thank you.
Okay, thank you.
Thank you.
So September 10th stays. All right. I will get you guys since I have it. All right, thank you, Your Honor.
All right, thank you. All right, so, Mr. Hackett, can you approach with the prosecutor?
I can't remember. Is it White Cloud or something? I can't remember the guy's name. Somebody help us. What's Chief Firewater's real name? Yeah, I get it. I was muted. You're not going to get this kind of content anywhere else. But by that I mean smooth jazz. While looking at Judge Aaron Gothier in text. I'm kind of feeling it.
We're back on the record and we've got,
I missed the music already.
will be Nicholas Malloy up for an arraignment and filed 24-6897FH. Counsel, you want to state your appearances, please?
Melissa Goodrich, Sheboygan County Prosecutor.
Good afternoon, Your Honor. Michael Hackett on behalf of
McLeod.
Nicholas Malloy.
That's right.
Okay, for purposes of arraignment in that file, is a forensic center referral requested?
No,
And you waive the reading?
yes,
Okay. And I have been presented with a plea agreement and it encompasses some of the pending probation matters. And all of those matters, he is currently on. Yes, looking at the plea agreement, the simplest thing would be to take all of it together. But that would require your client's waiver of the non-public provisions of HIDA for this hearing only. Do you, would the defense consent to waiving the non-public nature of the proceeding on the probation matter?
Yes, Your Honor. In light of the resolution of the cases in total, we think it's reasonable that we would waive the non-public nature of the first charge, the HIDA charge.
Okay.
All right.
All
What are you
right,
on?
and you consent to the filing of the amended information in 6897 for purposes of plea taking.
Yes, Your Honor.
All right, Mr. Malloy, as best you can, would you raise your right hand for me? Swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, Your Honor.
Okay, you put your hand down. And are you Nicholas Jerome Malloy?
Yes, Your Honor.
Mr. Malloy, a guilty plea hearing is an important event. It includes the waiver of constitutional rights that you have. So I want you to listen carefully. If you have any questions, go ahead and ask me. If you have any need to talk to your attorney some more, just let us know. We're happy to give you that time. Do you understand that?
Yes, Your Honor.
Now I have to advise you the maximum penalty at stake here. Under this agreement, you'd be pleading to the following charges. In the amended information, count 1, possession of methamphetamine, which is a felony punishable by 10 years and or $15,000 fine. Count 2, fired by a prohibited person. It's a felony years and or $5,000 in mandatory forfeiture of the weapon or device. I'm sorry, these are as habitual third. So count 1, possession of methamphetamine with the habitual would be a maximum of 20 years, and the firearm possession a maximum of 10 years. Count 12, carrying a concealed weapon is a felony, and with the habitual third would be punishable by a maximum of 10 years and or $2,500 mandatory forfeiture of the weapon. Count 15, altering identification marks on a firearm. With the habitual third would be a felony punishable by up to 4 years and or $1,000 in mandatory forfeiture of the weapon. Count 16, operating while intoxicated, second offense. It's a misdemeanor punishable by $200 to $1,000 fine and or 5 days to 1 year in jail.
Oh, yes, there's
or
a chief
30
firewater
to 90
pilot.
days community service or both. The court could order rehabilitative programs, cost of prosecution, and reimbursement for emergency expenses and vehicle immobilization. Count 17, operating with a suspended license, second offense. It's a misdemeanor punishable by 1 year and or $1,000. Count 18, operating without security or insurance. It's a misdemeanor punishable by not more than a year and or a fine of between $200 to $500. You understand the maximum penalty for those charges?
How do I do that?
Yes, Your Honor.
Also, you'd be pleading to counts 1 through 4, 6 through 7, and 9 through 13 in the pending probation violation files. And the maximum penalty you're facing in those files in file 6653 is resisting obstructing, a maximum 2 years. 6654, possession of methamphetamine, maximum 10 years. 6655, possession of jail contraband, maximum 5 years. 6672, possession of methamphetamine, maximum 10 years.
We're working off the
And
battery.
I could revoke your probation and sentence you to those maximums in those files. Do you understand the maximum penalty that you could face for all these matters?
Yes, Your Honor.
All right.
Let's work
And
on
do
it.
you understand if you
I'll talk with Mike's
enter
IT
a plea,
problems in
you
real
won't have
time.
a trial of any kind, and you'll be giving up the rights you would have had at trial?
Yes, Your Honor.
I want to remind you the most important of those rights. You'd have the right to be tried by a jury and at that trial be presumed innocent unless and until the prosecutor proved your guilt beyond a reasonable doubt. You'd have the right to have the witnesses against you appear and to question them. You'd have the right to present witnesses in your own defense
Right, I'll
and then
try.
order them to show up. You'd have the right to testify in your own defense or remain silent and not have your silence used against you in any way. Do you understand all those?
Yes, Your Honor.
Do you have any questions for me or your lawyer about any of those rights?
No, Your Honor.
Do you wish to give up those rights and enter a plea according to the terms of this agreement today?
Yes, Your Honor.
You also understand you have the right to have a hearing on the alleged violations of probation where they need to be proven by preponderance of the evidence, the right to assistance of an attorney to present evidence in your own defense. Do you understand those rights?
Yes, Your Honor.
Do you wish to waive those rights as well?
Yes, Your Honor.
If I accept your plea, you can't come back later and tell me that it wasn't your own free choice for any reason, including other promises or threats made to you. Do you understand that?
Yes, Your Honor.
Also, when you enter a plea, you waive the right to appeal. And if you wanted to appeal, you'd have to seek permission by filing an application. The types of issues you could raise on that appeal after a guilty plea are much more limited than if you were convicted after a trial. Do you understand that?
Yes, Your Honor.
Plea agreement provides in exchange for your plea to the charges that I outlined. The prosecutor will dismiss the remaining charges and a drug double enhancement and dismiss counts 5 and 8 of the probation violation matters.
Okay,
There
is
is
it
a
better
sentence
now?
agreement for the Sheboygan County Recovery Court program. Do you understand the terms of that plea
I
agreement?
had the power
Yes, Your
plugged
Honor.
in.
And Mr. Hackett, is that a full, fair, and accurate statement of its terms?
Yes, Your Honor.
Ms. Goodrich?
Yes, in addition, the weapon that was found in the vehicle would be forfeited.
Yes, and the weapon will be forfeited. Do you understand that, Mr. Malloy?
Yes, Your Honor.
All right, now, Mr. Malloy, the recovery court team has reviewed your cases and determined that you're an appropriate candidate for our program. But the final decision would be mine at the sentencing date. And so I'm not bound by this, but if I did not continue you in the recovery court program at that time, you'd be allowed to withdraw your plea. Do you understand that?
Yes, Your Honor.
Now that's unless you do something really dumb like abscond or commit a new crime, violate court orders, things like that. That kind of misconduct could cause you to lose the right to withdraw your plea, even if I don't follow the agreement. Do you understand that?
Yes, Your Honor.
Other than the plea agreement, has anybody promised you anything to get you to plead guilty?
No, Your Honor.
Has anybody threatened you to make you do so?
No, Your Honor.
Is entering these pleas your own free choice today?
Yes, Your Honor.
Knowing all this, how do you wish to plead? In file 6897 to the charge in count 1, possession methamphetamine.
Guilty.
How do you wish to plead to the charge in count 2, possessing a firearm by a prohibited person?
Guilty.
How do you wish to plead to the charge in count 12, carrying a concealed weapon?
Guilty.
How do you wish to plead to the charge in count 15, operating while intoxicated, second offense?
Guilty.
How do you wish to plead to the charge in count 16? I'm sorry, that was 16. 15 is how do you wish to plead to the charge of altering firearm identification mark?
Guilty, Your Honor.
And count 17, driving on a suspended license, second offense.
Guilty, Your Honor.
And count 18, operating without security.
Guilty, Your Honor.
All right, and so on or about July 20th of this year, were you in Sheboygan County?
Yes, Your Honor.
Did you end up having some contact with law enforcement?
Yes, Your Honor.
Were you operating a motor vehicle?
Yes, Your Honor.
Did that vehicle have in full force and effect the insurance or security required by Michigan law?
No, Your Honor.
Did you have a valid driver's license?
No, Your Honor.
And did you have a prior conviction for operating with a suspended license back in 2023 in the 89th District Court?
Yes, Your Honor.
Before you operated the vehicle, did you consume a controlled substance?
Yes, Your Honor.
Were you under the influence of that substance while you were operating the vehicle?
Yes, Your Honor.
And did you have a previous conviction for impaired driving in 2020 in the 90th District Court?
Yes, Your Honor.
Were you also in possession of a firearm?
Yes, Your Honor.
Was it inside the vehicle?
Yes, Your Honor.
Do you have a permit to carry it inside the vehicle, which constitutes concealed carry?
No, Your Honor.
Did the pistol have the identification marks removed?
Yes, Your Honor.
And did you know that?
Yes, Your Honor.
Were you the one that had removed those marks?
Yes, Your Honor.
And due to your prior convictions, were you not allowed to possess a firearm in any respect?
Yes, Your Honor.
Were you also in possession of the controlled substance methamphetamine?
Yes, Your Honor.
Did you know that it was methamphetamine?
Yes, Your Honor.
Did you have any lawful authority to possess that substance in Michigan?
No, Your Honor.
Mr. Hackett, you satisfied with the factual basis?
Yes, Your Honor.
Ms. Goodrich?
Yes.
And Mr. Hackett, do you believe that that also simultaneously constitutes the factual basis for the probation violations?
It does, Your Honor.
Ms. Goodrich, do you concur?
Yes.
All right, Mr. Malloy, I find that your plea is knowingly, understandingly, and voluntarily made, and that there is a sufficient basis in fact and law to believe you're guilty of those offenses. So I hereby accept your plea. We'll have to schedule sentencing Maybe we should put it out a little bit to get him rolling in recovery court, maybe October 8th. Any objection to that, Mr. Hackett?
That'd be workable. Thank you.
Okay. Afternoon or morning work better for you?
Morning.
How about we just do 9 a.m. work?
Fine.
Okay, we'll schedule sentencing and probation violation sentencing in all these files for October 8th at 9 a.m. in the courtroom. And Ms. Goodrich, do you want Mr. Malloy to begin immediate participation?
Yes.
Mr. Hackett, do you have any objection to our amending the bond to allow him to begin the program and have him attend review hearings without you being present?
No, Your Honor, I have no objection. Yes, I would request that.
Okay. All right, so Mr. Malloy, we're going to amend your bond in all the files to $5,000 personal recognizance bond with recovery court conditions. That means you'll be released. If that paperwork gets done today, stop by and see if you can see Nicole. It's a busy afternoon. I'm not sure that'll happen today, so we might bring you out in the morning for recovery court. If it does get done today and you get released, you have to be here tomorrow morning at 9:30 for the beginning phase of participants. You'll be seeing me once a week on Wednesdays. And Mr. Hackett won't be present at those review hearings, just to see how you're doing in the program. We won't talk about your case. We have a defense attorney on the team, but he's not your lawyer. If there's anything that happens at those review hearings, if you're progress that you're uncomfortable, you just let us know. We'll pull the plug on it until you have a chance to talk to Mr. Hackett. Do you understand that?
Yes, Your Honor.
All right, anything further from the defense?
Not about this issue.
Okay, Ms. Hackett, or Ms. Goodrich, anything from
No, Your Honor.
another issue, Mr. Hackett?
Your Honor, there were a number of long guns that were seized as a part of the follow-up, and those guns didn't belong to Nick. We would request they be returned at this point in time. Mr. Jerry Malloy is here in the courtroom, and he's the owner of most of those guns. We would request that they can be returned at this point.
Ms. Goodrich, your position on that, and do you know precisely which firearms are at issue?
Yes, Your Honor, no objection to that. I don't know if the standard terms of recovery courts include no use or possession of weapons. If not, I would just ask that be added to Mr. Malloy's.
Well, he's currently on probation in all these other files, and that is a condition of those probationary terms.
Okay.
So if that's sufficient, so to the extent that you need a court order to facilitate that, is that possible to submit a stipulated order?
Sure.
Okay, that's suffice.
Fine.
Mr. Hackett. Okay.
Fine.
All right, very good. Anything further?
Well, there was also a cell phone that was Nick's. And quite frankly, we need the cell phone in order to cancel the apps that are running an expense. And maybe we request that return that cell phone be included.
Your Honor, we typically don't do that because this is a delay of sentence, but at the end of his hopefully successful completion of the recovery court is when we would look to return something.
So if there's a need to access the device to cancel certain services, is that anything that can be like a meeting to maybe through counsel? Is that something you can explore?
Sure, I'd have to explore that.
Your Honor, if I may, the probation office currently has possession of the phone.
Oh, you got it.
Yeah, so it's something that we're looking at, while having the phone looked into.
Okay, so it looks like it's tied up right now, Mr. Hackett, but I'd encourage you to consult with the probation department.
I was under the impression it was off in a forensic lab somewhere, so.
Might be on its way. I don't know.
Okay.
I mean, do you need to approach? Is there anything about that that could blow this up? That we should talk about off the record or?
Possibly.
All right, well, let's just open this. All right, Anything further then?
No, thank you.
Ms. Goodrich?
No, Your Honor, thank you.
Okay, Mr. Malloy, I'll see you tomorrow morning. Okay, and we'll get you rolling on this program.
Come on, Chief Firewater.
Yeah, right. Mr. James and Mr. Hartman are in Zoom. Didn't we adjourn? Afternoon, Mr. Hartman. All right, we're up next in People v. Mitchell James. It's file 24-6840 FH. So Mr. Hartman's appearing by Zoom video. Mr. James is present in the meeting. Let's see if he can turn on his camera here. And Mr. Hartman, what's our status in this matter?
Your Honor, I've received correspondence from Prosecutor Goodrich that they are requesting one final status conference to finalize restitution. And I don't oppose that.
Okay. How about, would September 17th give you sufficient time, Ms. Goodrich?
Yes, I'm meeting with the victims next week. Mr. Hartman provided me a spreadsheet of his proposed restitution. So we should be able to resolve this hopefully by the 19th.
Okay. Maybe schedule this for September 17 at 1:30 in the afternoon, Mr. Hartman?
Yes, Your Honor.
And Ms. Goodrich, any objection to continued video appearance?
No objection.
All right, so we'll set it for a continued docket call on Tuesday, September 17 at 1:30 in the afternoon and continue to allow video appearance. Anything further from the defense?
No, Your Honor.
Anything further from the people?
No, Your Honor, thank you.
Okay, we'll see you then. You have a great day.
Thank you.
We had a Michael Wing up for arraignment with Mr. Kearney, but I don't see anybody zoomed in for that. That's the case. Good afternoon. On the Nokia phone, can you tell me what your name is?
Amy Jarvis.
Oh, Mr. Gilbert, that's your file, isn't it?
Yes, Your Honor.
All right, this is People v. Amy Jarvis, file 23-6747 FH. For arraignment, Ms. Jarvis is appearing by video. I note that this was a case that we had been continuing to track the outcome of a motion filed in another case by Mr. Burgo about whether SORA constitutes an ex post facto law. On today's date, I did deny that motion. So I don't know if you wanted to separately file a motion and make any arguments or set for the docket call or what you want.
I would ask you, Your Honor, I found out about the results of the motion earlier today. I would ask that we set it up for one more docket call and then hopefully we can have it resolved.
Okay, that's sensible. September 10 or September 17?
Which one's later at this point, Your Honor?
They're not too bad, but probably the 17th. Well, we put it on that.
Excellent, thank you.
Okay, so Ms. Jarvis, will you come back on September 17 at 2:10 in the afternoon? Okay, and our Zoom appearance is working well with
They're
communication.
fine, yeah, she's been in communication.
Okay, we'll go ahead and continue to allow video appearance then. All right, anything further from the people?
No, Your Honor,
From
thank
the
you.
defense?
No, Your Honor, thank you.
Okay, we'll see you then, Ms. Jarvis, September 17th, 2:10.
Okay, thank you.
Ms. LeBlanc. And this is sentencing in People v. Alyssa LeBlanc, file 22-6478FH. Counsel, please state your appearances.
Chief Goodrich, Wayne County Prosecutor.
Luke Gusky on behalf of Mr. LeBlanc, Your Honor.
All right, good afternoon, and I did receive several letters of support for Ms. LeBlanc. One letter from family that I don't think you could characterize as supportive, and a confirmation from Mission Bible Training Center in Gastra, Michigan. Is that Iron County or Delta? What county is that? It's way up on the border.
Crystal Falls.
Okay.
I'm not familiar, Your Honor.
That she's been accepted into their program.
Yes, Your Honor.
So I have had a chance to review, as well as a Center for Addiction Recovery Training Certificate of Completion of some programming. All right, so I have had a chance to review those. Have you had a chance to review the probation violation report with your client?
Your Honor, yes.
Any additions or corrections?
These are corrections to that report.
Ms. Goodrich, any additions, corrections?
No, Your
Tesky, go ahead with any others.
Thank you, Your Honor. Your Honor, Mr. LeBlanc comes before the court on a sentencing on a probation violation. She had 8 months on probation before the violation that had occurred in this case. At that time, she had done some treatment. She was in counseling, working towards being a peer recovery coach. One of her mentors in that training and counseling and working on getting her in peer recovery subsequently passed away, and here we have a relapse, and Ms. LeBlanc finds herself in the situation that she's in with case at hand that was charged, has led down to use. She recognizes that her conduct was obviously wrong in this situation. She's very remorseful for that. It's not often as resourceful as Ms. LeBlanc in trying to get herself some help and some recovery. Incarceration in county jail, she was able to several different counseling options. I know Your Honor denied our first one. I think we never ask again, consider that understanding was not inclined to give her in the first place. And so I do think, and I would request that the court consider that as an option. She's had an addiction problem. She's had a relapse here, and she needs some more help with that. She has a great support system. She has several people here in the courtroom that are of her. She works with the tribe. She has a tremendous amount of people that are working with her through that service and through those services that she receives up there for her treatment and counseling as well. And as Your Honor may recall this case and the probation violation hearing that we had, it is a residue case. I guess it was a use, and that's what she had pled to, but certainly with the residue, Your Honor found that there was evidence to support the possession violation for, and reading through the report from Mr. Fagan, this would be her first probation violation that she I don't see that happening again. I think definitely back on the right track, putting the right foot. And as I said, I've never seen anybody as tenacious as she is to just get help. I deal a lot of people, and you almost got a problem to get there. To get these services and to help tap into those things. And so
All right, I'm ready to give up.
Them wanting it and trying.
I don't think this is happening.
That help that they need. I thought the recommendation by Mr. Fagan was appropriate, given the conduct, given that she didn't have any violations before.
Unless somebody sees that it's on
We
a
asked
call
the court
sheet or
to
something.
adopt those recommendations and sends her accordingly to those recommendations by Mr. Fagan, Your Honor. Thank you.
My information
Thank
was
you.
it was set
Ms.
for 1:30.
LeBlanc, you don't have to say anything today
Eastern.
for disallowed. Is there anything you want to tell me?
Thank you, sir. I want to sincerely apologize for my bad behavior to this community and you. And sitting this jail time has made me
Okay.
realize that I do not want to continue
I'll hang up.
on the path that I was. And I want victory over my addiction. Thank you.
Now, I have this letter that you've been accepted into the Mission Bible Training in Michigan. Do you want to participate in that program?
I do have a 2-year-old baby to get home to, and I do have services to the tribe. My tribe is very drug court. They're very big on drug courts. I have counseling set up north. I have recovery coaches. I have 2 of them up there.
Well, I
And
guess I'm just wanting to confirm from you, because the letters that I got from folks, and including a letter from you, sounded like asking me to give you a chance to attend.
yes,
Okay. The reason I ask is because it's a religious oriented facility. I can't order you there, but if you
Oh,
ask
good
me
Lord. Now we have.
if you want to go there, I can amend your probation to facilitate that.
okay.
That's what you want to me to do that.
Yeah, I do. I do. I honestly, I don't know, just because I have a baby at home. That's my only, if he about it, just,
Ma'am, are you a whore? You're not a whore? Not a whore? You're not a whore? I never want to hear it again. Sweet Jesus. You're not a whore? Not a whore? You're not a whore? I never want to hear it again. It gets worse.
There were drugs involved that were given to me that ended up being glue. Like I smoked some glue and stuff. I thought I was smoking crack.
Let's go.
You didn't say the cat jumped on his wiener, did you? Sit down and shut up. Shut up. Shut up. Cat jumped on his wiener. Cat jumped on his wiener. Shut up. Cat jumped on his wiener. Cat jumped on his wiener. Shut up. Cat jumped on his wiener. Cat jumped on his wiener. Shut up. Cat jumped on his wiener. Cat jumped on his wiener. Shut up.
Can you just let this go for once? For once? Once? Okay, that being no. Get a word. I never want to hear it again. You a whore?
Mr. Sharts.
Not a whore?
Mr. Sharts. Mr. Sharts. Mr. Sharts.
Everybody fucking dance.
You're not a whore? You're not a whore? I never want to hear it again. You're not a whore? You're not a whore? I never want to hear it again.
Now, if anybody thinks this is okay, I am in the wrong.
There is no schedule at Law Talk Nation. You can only pay, you get a notification. If you're lucky, it's a spicy fornication. It's another day on Law Talk with Mike. We got preacher on the dial, letting always make your chest smile. The pro say can't ever share a file. Defendants are always in denial. He was not driving, he's traveling. His reasons and facts are unraveling. It's another day on Law Talk with Mike. is always popping up. You have a failure appear and you scoff. Judge Simpson is never going soft. Webster is always showing off. We are heading into that soft 6 summer. Did you miss the line? That's a bummer. The soft 6 never gets smarter than dumber. He's not the man, he doesn't need a number. He was not driving, he's traveling. His reasons and facts are unraveling.
All right. I'm officially throwing in the towel. I gotta run anyway. I'll check if it ever comes on and it's good. I'll do a video on it. Sorry. All right.
Courtroom is always popping off.
All right, we're back on the record and continuing with Ms. LeBlanc, I wanted to give council an opportunity to discuss with Ms. LeBlanc.
All right. I'll hang a little bit long.
This time, Your Honor, asked the court to follow the recommendations of the probation department.
Okay.
Although there is long-term treatment there, I know I had one child that is older that she's lost custody of and has not had time with him. Long-term treatment, watching them has become quite, although she relished the opportunity, not having the more conducive avenue for her would be to get out to get with her child to start recovery with them.
Okay, that's fine. Ms. Goodrich, any recommendations from the people?
I would ask the court to follow the recommendations of the 6 months jail. Thank you.
All right, well, given the nature of the violation, the progress that had been made prior to and the recommendation of the Department of Corrections, I'm going to go ahead and follow that recommendation. So Ms. LeBlanc, I'm going to continue you on probation. So we're not going to revoke your probation at this time. So we'll do the appeal rights. We're not going to enter a judgment. We'll continue on probation. We'll amend the probation order, however, to have you serve 7 months in the Sheboygan County Jail with credit for 134 days previously served. So then upon your release from the jail, you're continued on probation. So within 24 hours of your release, you have to contact your supervising agent and continue with the probationary terms and hopefully continue with some treatments that you've said you wanted so that you get on a better path. Okay. All right.
Thank you, Your Honor.
Good luck.
Thank you.
All right, and to help facilitate the jail, we'll call People Be McLeod next.
Good afternoon again, Your Honor. Custody on behalf of Trevor McLeod.
All right, and all right, this is file 23-748FH. And who do we have from the people on this file?
That would be me.
Okay.
What's Goodrich, Sheboygan County Prosecutor?
All right, and we're here for a docket call and also then a contempt hearing for failing to appear. But I do note that there was an absconding case filed in that matter. So Mr. Kukuski, do you know how Mr. McLeod wishes to proceed today?
Well, Your Honor, we're not resolving this matter at this time. We'd ask that the hearing be continued at this time as well, given the new charge in that matter. Sorry.
I do see that the new charge is set for an arraignment on September 10th. It was at 10 a.m. You want us to continue this to the same date and time?
Yeah, Your Honor, that'd be
fine. Okay, so let's continue this to a docket call to September 10th at 10 a.m. And we'll have the contempt hearing, same date and time. And that'll be the same time as the arraignment on the absconding charge as well. All right, anything further from the defense?
Briefly, Your Honor, I did want to request from the court a consideration on reinstating Mr. McLeod's bond. He is self-employed and has several jobs and opportunities lined up. This is the time of the year that he gets his work in as a contractor, kind of puts things away for the winter months. He's the sole breadwinner for his family. And support for his wife and children. He's obviously no longer listening to outside forces and taking bad advice. He's now retained counsel. To my knowledge, he had no failures to appear. He did fail to appear one time, which led to his incarceration and his sitting and bond being revoked. To my understanding, that's not going to happen again, Your Honor.
More
He's
than
got
just that.
significant ties to the community. He is still in the community here.
Oops, I didn't have.
And so we'd ask the court to, and even on these charges, he's not looking at any sort of lengthy sentence.
I'm not sure that's true. He's got an absconding felony charge now that's discretionary consecutive. I mean, I haven't scored it, but
Sure.
he's really made a mountain out of the proverbial molehill here.
I would agree with Your Honor. I mean, he had a lead to a disorderly person. Certainly, that's gone to the wayside at this time. But we're just asking for the court to look at all those factors and weigh that into considering a release on bond again, Your Honor, and not to, I guess, hold. He's listening to bad advice, which he's not doing anymore against him, and come down from a place of anger, but to allow him the opportunity again. Thank you.
Thank you, Ms. Gooders, people's position.
Your Honor, my concern would be the pending absconding and his demonstration on bond of failing to appear. He has had the benefit of previous counsel throughout this case. I'm glad that he has retained counsel and appears to be communicating with that attorney. However, I still have concerns with his ability to appear for future court hearings.
All right, well, I mean, last time when I was here, I noted that we had gotten mail back from Mr. McLeod. A second one came back that I guess had been kind of lingering. And again, just for the record, when he was purporting to represent, when he was representing himself, then he refused mailing from the court. I have a second mailing back from the court. And this is not somebody else's. I mean, I don't know where he gets the advice, but this was an adult man choosing, while he's representing himself, to write on it in red ink, return to sender 18 U.S. Code 241-242, your offer to contract is not accepted, as if a defendant facing a pending felony charge has some ability to reject a contract and ignore the case. So this was really quite a willful refusal to acknowledge even the authority of the court, and an outright refusal to appear, resulting in a forfeiture of the bond. And I mean, when people are facing a felony case, even though this wasn't the most serious felony case that we see, it is nonetheless serious. It's in the circuit court, court of general jurisdiction. People don't just get to opt out of that and say, I don't think the courts have any authority over me. Well, guess what? They do. And so I just have no confidence that Mr. McLeod respects the authority of any governing authority, and that he would appear. He's refused to appear and now has an absconding charge. So his bond will continue to be revoked until the conclusion of these cases.
Boom.
Thank you.
Thank you.
Fantastic. That was worth the wait.
She's from the France firm.
And to his credit, he took it better than Chili.
Good afternoon, Ms. LaCrosse. What case are you here for?
I'm here with the France.
All right, well, there you have it. We did get to Chief Firewater. Woo! Sorry, this is a mess. Where I'm at has bad Wi-Fi, and the only outlet is not near the desk, so I have to hold the whatever. Don't worry about it. Don't worry about it. It's just, you know, it's travel troubles. It's, yeah, you know, I'll get through it. Don't worry about me. Thank y'all for coming out. I appreciate it.